Hey, in this video, I'm going to talk about the difference between a pour-over will and a regular will. I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. As a bonus on this video, I'm going to give you a shot of our beautiful Louisiana sunrise over my left shoulder. Okay, so the reason I'm doing this video is because I get so many questions. What's a pour-over will? And sometimes, they get the pour-over word messed up. But anyway, what's a pour-over will? I get that all the time. So I came up with the term for purposes of this video, regular will, because if someone doesn't have a pour-over will, they're going to have a regular will. And so I really need to give you the background so you can have a good understanding of really what a pour-over will is all about. First, let's talk about the regular will. So the regular will is the kind of will that you probably think a will is. It's when someone gets their will written by a lawyer or they do it themselves. And their will is going to have provisions. It's going to have all those bequests in their will. May have some specific bequests, may just leave things generally. It may say I leave my estate to my spouse, and if my spouse dies before me, I leave it to my kids. It may say I leave my estate to my kids. It may say I leave my estate to my kids equally. It may say I leave my estate to these people in these percentages, which add up to 100. A will might say I leave $25,000 to each of my grandchildren and the rest to my children equally. Wills sometimes have specific bequests. I leave $10,000 to the St. Jude's facility in Memphis, and I leave the rest of my estate to my daughter. Or a will might leave things to what's called a testamentary trust, a trust that's in your last will and testament. I leave my estate to a trust for my spouse and my children, so my spouse can use those trust assets while my spouse is alive. And then when my spouse dies, those trust assets revert back to my children. Or here in Louisiana, some wills say I leave the usufruct to my spouse and I name my children as the naked owner. So all those are kind of common regular will provisions. Now, when you die with a regular will, your assets are going to be frozen, and all of the people that are inheriting or will play a role in settling your estate, they're all going to be part of a court proceeding, typically known as probate. Because when you die with assets in your name, it's our court system, which has for many, many decades now has been assigned the responsibility of overseeing the administration of what somebody owned and the ultimate disbursement to the heirs. So if dad, it's just the way it is. If dad had a will, a regular will, and he named Ed as the executor, and in his will he had a bequest of $10,000 to Tommy, and if after dad dies, Ed the executor and Tommy the recipient of the $10,000 bequest, if they go to dad's bank and they go to a bank officer and Ed pulls out the will and says, here's my dad's will, he died 3 weeks ago. You'll see in the will, dad named me, Ed, as the executor, and you see in the will, dad left $10,000 to Tommy. Since we're here, we'd like you to go ahead and access dad's bank account and give that $10,000 to Tommy. If you're Ed and Tommy and you go to the bank and do that with dad's will, they're going to laugh at you. So they're going to laugh at you first, and then they're going to tell you something like, you need to go get lawyers. You need to go through a court process. You need to go through probate. Or they might say, we need to see the appropriate court orders directing us what to do with your dad's account because we're required to freeze it now that your dad has died. So you're going to hear something like that, and typically heirs in regular wills hear that when they try to kind of settle the estate by themselves. They get shut out pretty quick. And if dad left his house or his part of the house to mom, and a couple of weeks after dad dies, mom thinks she's going to sell the house. It's too much for her to manage. She's going to pretty quickly find out she can't, either from some title examiner or some real estate agent who's somewhat on the ball. But a buyer will never buy that house from mom because it's titled in dad and mom's name. And so that title examiner for the potential buyer needs to see all of the appropriate court orders recorded in the parish or county where the house is, ordering that the house that previously belonged to dad and mom now belongs to mom only. So heirs of regular wills, when they try to settle things kind of on their own, they get shut out. They quickly realize they've got to go hire lawyers and go through a court process. That's, it's going to take months, if not years, and it's going to be a hassle. So that ought to give you an idea of what the regular will is. Now we're primed and prepped to go over what a pour over will has. So if someone has a pour over will, it definitely means there's some trust out there. The typical pour over will is set up as part of an overall trust-based estate planning legal program where someone wants to avoid their survivors having to go through that probate or that court process when they die. So they set up what's typically called a revocable living trust. They retitle their home and those assets that had previously been in their name that would have been frozen when they died. They retitle those assets into their trust, and their trust really replaces their will. So in their trust, it may say, I name Ed as the successor trustee of my trust to handle matters when I die. Out of my trust, when I die, I want $10,000 to go to Tommy, or my interest in the home that's in the trust, I want that to go to my spouse. So all those provisions that were in the regular will, they're now in the trust. So some people say, well, do you need a will if you have a trust? Now we get to the pour over will. So the strategy with the trust was to eliminate the lawyers and the court proceedings and all that goes along with what happens when you leave things in your name and use a regular will to provide for the disposition of that. So when you have a trust and you have things titled in your trust, it's unlikely that a will is ever even going to need to be used. However, sometimes people die and they had set up a trust, and maybe some of their assets are in the trust, and maybe some assets either intentionally or mistakenly or because they forgot or whatever. That's another video. There's still some assets in their name when they die. Maybe there's a few shares of stock that they forgot to retitle in their trust. Maybe they bought a piece of property after they created their trust and they forgot to buy it in the name of their trust. They bought it in their name. So they died and there's these assets that are in their name. That's where the pour over will comes into play. So those assets that are in their name when they die, they're going to be frozen. And then the pour over will needs to be used to go through the court system to transfer only those assets that remained in the deceased person's name. Use the pour over will. The pour over will is probably going to have a statement like, whatever's in my name when I die, that's not in my trust, I leave it to my trust. So it pours over those assets that were in that individual's name into the trust. So then the trustee can disperse the trust assets pursuant to the terms of the trust instrument. So that pour over will, it's there just in case you have some things in your name when you die, and we got to go through the probate system to get those things from your name to the trust, so then they can be dispersed without any kind of court supervision to the trust beneficiaries. Now, in an ideal situation, that pour over will never needs to be used because everything's titled either in the trust, or maybe you have an IRA that has designated beneficiaries, and you have everything structured in a way so that there's no attorney and court involvement in going through anything at the courthouse or anything, through that probate system. So that pour over will, it's there when someone has a trust that they use as the vehicle to disperse their assets to their heirs. But that pour over will needs to be there just in case there's some things in that individual's name when they die, and we got to go through the probate to get it from the person's name to their trust. We use the pour over will to do that. All right, make sure you subscribe to our channel. That way you won't miss any of these educational estate planning videos. Hit the thumbs up, hit the notification bell when you subscribe, comments down below. We'll see you next time.